Good morning, everyone. Are we ready to go?
We are, Judge, and we have no other interpreter cases this morning.
All right. Thank you so much. And Mr. Davies, I've been informed your case will be last, although there's not that many.
No problem, Judge. I'll stand by. Thank you.
All right. Max, is it Steve, maybe? Or Seven?
Steve, Your Honor, I believe.
And then Corey Hernandez.
We're asking for a continuance in that matter, Your Honor. On Mr. Steve.
All right, this looks like the first one, so we'll see him tomorrow. Hernandez and then Johnson.
Good morning, Judge.
Good morning, Mr. Hernandez. What does the state feel is appropriate on this matter?
Good morning, Your Honor. State is seeking $10,000 bail along with pretrial services and testing for controlled substances. As you can see, the defendant scores highly on the risk assessment with a 14. He has a citation pending in Reno Municipal Court for possession of drug paraphernalia. That's from this year, 2026. 2025, possession of drug paraphernalia out of California, conviction. Looks like a bench warrant was issued related to that case. Then he also has possession of drug paraphernalia case in 2025 here in Reno Municipal Court. He was sentenced with probation with community court type treatment conditions. He was revoked in January of this year on that sentence, did not comply. Has other misdemeanor convictions in 2025. He is a convicted felon. That's from 2021, grand larceny of a motor vehicle. He was released on his own recognizance in that case. That was a local case to go to Salvation Army. He never checked in. He did not complete that program and his OR was revoked. He's got 6 other prior felony convictions dating all the way back to 2010, which include robbery, taking a vehicle without consent, carrying a concealed dirk or dagger, participating in a criminal street gang. Those are all out of California. So the defendant continues, he's now 37 years old, continues to commit criminal activity. So the state believes that $10,000 with monitoring and testing is appropriate.
All right, thank you. Comments?
Thank you, Judge. I don't know what it takes for people to change, Your Honor, but Mr. Hernandez has communicated a willingness to change. He's asking for a release to an IAP program, and he's willing to participate in that program and work through the inmate assistance program in order to receive that treatment. So we're not arguing about bail per se. We're asking for the opportunity to enter into the program and get the opportunity to receive treatment.
Maybe we should make that a box on here. States shown by clear and convincing evidence of bail, even outside the defendant's ability to make it, is necessary to ensure the safety of the community and clearance of the defendant. If we set it $10,000, pretrial services will notify the court and counsel of any new arrest. I will allow direct release to residential if the evaluation supports that level of care and transports with IAP. Next court date, January 30th at 9 a.m.
Thank you. Good luck, man.
Want to get out?
Nope. You're in a good program. Okay, your chance. Don't start your shit.
All right.
Johnson and then Rogers.
We don't have Johnson either, Your Honor. We're asking for continuance in that matter.
I think that's already been continued. So by policy, we'll go forward. What's the state's request?
Yeah, we know that Ms. Johnson has severe mental health issues, so we are asking for $1,000 bail. That hopefully that would be enough to determine whether we're going to go forward on the charges or not. Even though she scores a 5, she was overridden. She has at least just in 2025 3 different cases that were all where she was deemed incompetent. So the state believes that she continues to be a community safety risk to not only herself, but the community by laying in the roadway. That's the same conduct she had in 2025. So again, for now, we're asking for $1,000 bail on Ms. Johnson with no conditions.
That's
And those are our concerns as well, Your Honor. We think she's right for an SB 89. However, we're not going to oppose the state's request for $1,000 bail. We think that's completely reasonable.
All right, I plan, Ms. Costa. I believe the bench has already voted supported. I just don't have the paperwork out yet. But I want to let the DA's office know that at some point in the future, I think we'll have an administrative order that is consistent with both the federal practice and the majority of states, where on low bails, unsecured bonds will be accepted. So I just want to let you know that. That means the defendant promises to pay, much like they do with bail bondsmen, but it'll only be on low level, probably $5,000 bonds or less. So bail in this case is gonna be $10,000. I don't think an unsecured bond would be appropriate. We'll probably add a box where even if it's 5,000, the judge could not allow the unsecured bond. Pretrial services will notify the court of any new arrests. So bail laws make all court appearances. January 30th at 9 a.m. will be the defendant's next court date. Thank you. Rogers and then Nelson. All right, what's the state feels appropriate on this matter?
Your Honor, state is seeking $10,000 bail with no conditions based on the gross misdemeanor possession of a dangerous weapon. He does score highly on the risk assessment out of 12, and probably most glaringly obvious is the fact that he was arrested on a DUI in 2024 out of this court. This court released him on his own recognizance over the state's objection. The defendant never checked in with DAS. He didn't do anything he was supposed to, and this court issued a bench warrant in the amount of $25,000 for that outstanding criminal case. In addition to that pending case, he has a felony conviction for sales of a controlled substance. Looks like 3 different counts he was convicted of. That was out of our first judicial district court in 2021. And then he's got a misdemeanor conviction for false ID out of Douglas County and possession of 1 ounce of marijuana or less back in 2021 as well. So the defendant is a high risk to not show up or comply with court orders based on his very recent prior conduct. So the state believes the $10,000 is appropriate.
I think it depends.
And Judge, if that's bondable, my client could afford that amount and make sure that he is able to deal with this case. That's, from what I show, his first failure to appear or failure to comply with court orders, and he doesn't have a history of violence. And since those are the primary 2 concerns in terms of Valdez-Jimenez, I'm asking for his release today with that $10,000 bondable.
All right, the defendant has performed consistently with his risk score, which indicated he was a higher risk to reoffend or fail to appear. Therefore, bail outside his ability to make it is necessary to ensure the safety of the community appearance of the defendant will be set at $50,000, random drug testing, daily alcohol testing, no firearms, checking with pretrial services as ordered. Well, bail laws make all court appearances. January 30th at 9 a.m. would be the defendant's next court date. Thank you. Patricia Nelson has 2 cases, and then we'll move on to Yosbel Perez Morales.
And we're going to waive Mrs. Nelson's appearance, Your Honor. We'll proceed.
All right, what does the state feels appropriate on these 2 matters?
Your Honor, we are asking for $20,000 on each case. Both cases are very similar conduct for this defendant occurring last year. These were arrest warrants where her and her co-defendant, Ms. Benham, go into these stores, steal, I think combined for these 2 cases was over $5,000. She scores an 8 on the risk assessment when she was arrested on these. Well, first of all, she got arrested on new charges, very similar to what the court sees here. It was a possession of a controlled substance, plus she had been in Walmart switching tags on items and then attempting to leave with those items or pay less than what they were worth. She was arrested. At the time, she not only had these 2 outstanding felony arrest warrants, she had 2 arrest warrants or bench warrants, 1 out of Sparks Municipal Court, 1 out of Reno Municipal Court, both for contempt related failure to comply. That Reno Municipal Court warrant is related to a petty larceny conviction from 2025. She failed to comply post-sentence in that case. She's got a 2024 conviction for no driver's license out of Reno Municipal Court. She also had numerous contempt warrants related to that for not complying post-sentence. And then she's got an arrest for PCS in 2021 out of Esmeralda County with no disposition, and then a DUI conviction back in 2018 out of this court. That new case where she was stealing items from Walmart, also same co-defendant, Miss Benham. So we are asking for $20,000 on each case, pretrial services supervision, no contact with the Lululemon store, as well as Miss Benham, the co-defendant. She did receive bail in the Sparks case this morning, which included testing for controlled substances with pretrial services. So I'm not going to ask for that condition in this case, and I'll submit it.
We'll submit it too, Your Honor.
Has she been arraigned?
Yesterday.
Yes, she was.
Okay, good. So the MSC is January 20th, the prelim is February 5th. January 28th, I should say, if I didn't say that. I don't think I did. 130. 20 grand on each case. Pretrial supervision. Conditions remain the same in the 400A case. In the 947A, it's 20,000, no contact with victim, random drug and alcohol testing, pretrial services supervision, bail laws, make all court appearances. January 28th again at 1:30 on each case. Thank you. Perez Morales and then Rodman. All right, what does Steve feel is appropriate on this matter?
Your Honor, the state's not going to object to an OR release, which I normally wouldn't do, but I know that Mr. Perez Morales is currently on pretrial services for a crime that occurred after this. He's been on pretrial in that case, I think, since late last year or fall of last year. I looked again this morning. He hasn't had any violations of his pretrial services in that case. He does score 7, which is moderate, so we are not going to object to an OR release. We would ask for pretrial services on this case as well, which the other case revolves around stealing from Home Depot as well. So we would ask for a no contact with Home Depot as part of his conditions.
No objections.
All right, any objection? All right, thank you. OR, no contact with Home Depot. Bail laws, make all court appearances. Pretrial supervision, January 30th, 9 a.m. Next court date. Rodman, Francisco, and then Stearns.
Good morning.
Mr. Rodman, what's the state feels appropriate on this matter?
Your Honor, the state was able to get a hold of the victim in this case. She is not asking for a no contact order, not afraid of the defendant. Oh, in fact, I think she wanted to be here. She's not. Is she in the waiting room?
We've let everyone in that's
okay.
That's here.
Okay, so she wanted the court to know that, again, she's not afraid of the defendant. Based on his risk assessment score of 6 and the facts of the case, the state's not going to object to releasing him on his own recognizance. We aren't going to ask for a no contact order, but we would be asking for no possession of firearms or weapons based on the domestic component of the case.
We won't
Any
be
objection
to those conditions.
All right. OR, no firearms, chain with the pre-trials. We do monitoring, which is notify us of any violation of this order, which mean new arrests, January 30th, 9:30 a.m. for arraignment next week. See that?
Thank you, sir.
Let's go up this one.
Yes, sir.
Stearns and then Mendoza.
Well, Your Honor.
Are you Mr. Stearns?
Yes, that's correct.
Come on up to the podium, sir. What does the state feels appropriate on this matter?
Your Honor, the state is going to seek bail in the amount of $10,000 based on his high risk assessment score. I realize it's only a misdemeanor However, the defendant has continuing conduct that revolves around the defendant being intoxicated and having run-ins with law enforcement. He was just sentenced last year for gross misdemeanor battery on a police or on a protected person. Actually, that was a REMSA person that he battered. He did straight time. Well, first they gave him probation, tried to get him into treatment. He revoked himself on that case and ended up just doing straight time. He's got numerous other misdemeanor convictions that revolve around intoxication. He's got a felony conviction for domestic battery third in 2022, 2 different battery convictions in 2020, another domestic in 2020. And his history goes on and on, back all the way to 1993 with his first felony conviction of DUI with a prior DUI out of California. So clearly substance abuse is an issue for this defendant. He continues to have run-ins with law enforcement because of it, and he is violent. His history certainly shows that. So based on that, we are asking for $10,000. We're not asking for any conditions.
Judge, we're asking
Right.
for release to the IAP program. Mr. Stern says he'd like another shot at getting sober. I think it's important that he had that opportunity and revoked himself from it, which shows that he's either going to be fully committed to it or he's at least going to remove himself from the program and not interfere with other people's opportunities. So if you give him that opportunity, then we'd ask for that.
So as you've seen, if people don't have, serious crimes of violence, I'll go ahead and let the process be handled by IAP. But in circumstances like this, I think it's best to use a motion practice so the parties can put forth and address his criminal history and his prior performance, and we can see if there's even a place willing to take him. Right now, the state shown by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant. We set at $10,000. Random drug and alcohol testing, pretrial services supervision, January 30th at 9:30 a.m. So next court date, obey our laws, make all court appearances. We'll see you back then, sir. Good luck to you. Mendoza,
No, I tried.
and then we'll be on to Clarice Parker.
Back to you.
All right, we'll see if it feels appropriate on this matter.
Your Honor, state's not going to object to an OR release in this matter. We were able to contact the victim this morning. He is not asking for a no contact order. He could not be present this morning, but he does not believe the defendant owns any weapons. He is in support of her release. But even though that his statements, the state is going to ask for a no firearms or weapons clause, and actually, she is convicted of a gross misdemeanor in 2024, but that's her only prior criminal history. That was a conspiracy to pander charge out of the 8th Judicial District Court. But again, no objection to release on our own recognizance. We are asking for a no firearms or weapons clause based on the domestic component of the case.
No objections, Your Honor.
All right, that'll be the order with pretrial services supervision. Well, actually, I'll do monitoring since then they'll notify us of any violation of this order. January 30th, 9 a.m. Obey the laws, make a court appearance. See you next week. Thank you.
Thank you, sir.
All right, Mr. Davies.
Thank you.
Clarice Parker.
Judge, I'm going to step aside as I believe we're done now.
Sure. Have a good weekend.
Cheers. Thank you.
All right, what is the state feels appropriate?
Thank you, Your Honor. State is seeking $25,000 bail for this single charge. We are not asking for any additional conditions. This charge will be added to the defendant's currently pending case, which I believe he's in on $250,000 bail for luring, attempted statutory sexual seduction, attempted child abuse, another luring count, and then an attempted child abuse. As you can see from the probable cause declaration, this charge stems from the investigation which led to those original charges. And then they found CSAM on his cell phone, a very young female child. He does score low on the risk assessment. However, this behavior and what he's currently facing are very serious charges. This only adds to that. It's a non-probationable offense unless he can prove that he is not at risk to reoffend, and it will make him a sex offender. So the state believes that the $25,000 is appropriate.
Your Honor, may I get some clarification? I think I'm aware of what charge is filed. Is that NRS 200.730? that a single count?
So there's nothing been filed in this case. It's just he's just been arrested.
Okay, so no complaints been filed. So
No complaint's been filed yet.
so case number 132961 is the one we're appearing on right now, and that complaint is going to be amended to add another charge. Is that correct?
Yes, yes.
Okay. I just was curious if there's going to be a separate case number or not. I have we filed a pending bail modification motion December 16th, pending a hearing, I think February 19th, to modify bail from, and I don't know if I'm getting ahead of my skis here or not, modify bail from he was originally charged. He had a cash option. He posted that cash option, came into court, got his ad booked on another charge, and that bail was revoked and the cash option was taken away. He's been sitting in custody since then. I was wondering if we could do as a package bail with adding a 10% cash option. If we could kind of figure that out right now, if that's realistic or not. I've had this bail motion pending for about over a month now, and still waiting another about 3 or 4 weeks to get in front of this A court to hear that. So I don't know if we can just do one bail to right now for all this charge and the pending new charge. I don't disagree with Ms. Casso with the $25,000 added bail. That seems realistic in light of the charges he has. If this is 20730, which is going to be charged, that's a 1 to 6B. That doesn't like grossly outweigh the existing risk exposure he has right now. In my existing motion, you can see he's a 62-year-old man. He's been in Carson City for 47 and a half years. He owns a house in Carson City. He's been working for the Department of Employment, Training, and Rehabilitation for the last 4 years. Confident he can get his job back, or his job is still available to him, with zero criminal history up until now at this point. I think ankle bracelets, V-check. The court has a plethora of options to ensure his location, his appearance, and to maintain that he is not further violating. And this way, and then one thing I will add to this is a unique case. I do have an investigator with retained on this case, but this is a case where I really need his access out of custody to access some devices in order to. We feel there's exculpatory evidence in some of these devices that we're already working with Ms. Gallimore about trying to meet with the DA and go through that. But I really need him out of custody. The 10% cash option was working really well for him. He had no pretrial violations with that initially when Mr. Gilbert represented him, and I don't think that was precluded in the subsequent rearrest or ad book. But it was kind of the can was kind of kicked down the road for us to deal with it down the road. And hey, we're down the road right now. We're all right here. And if we could do like maybe, I don't know, $275,000 with the 10% cash option, I mean, I think that would be reasonable. Add a ankle bracelet on him, regular check-ins. Again, he owns a house in Carson City. He's got deep ties to the community. And that's where we're at.
Ms. Casso?
Well, Judge, I would ask to not have the bail hearing on the underlying charges at this point. I do see that Mr. Davies filed that motion. It looks like Ms. Gallimore filed an opposition to that motion. I certainly was not ready to argue the complete case this morning. I was focused on the original or the probable cause determination that we had before the court. So I would ask either to determine that bail for the charge that we're here on today, or to set a bail hearing perhaps next week or within a week to determine the bail for the entirety of the case. I plan on filing the amended or getting it prepared. It'll be filed on Monday. So that would be the state's request.
I mean, if we could have a bail hearing next week, that would be excellent. But ran into some obstacles about which department getting into. And I think we're set for February 19th for a prelim and a bail hearing at the same time. I really would prefer to separate those. Originally, the bail hearing was set for 10 o'clock in the morning, and I went on a status conference, and we kind of reluctantly or begrudgingly kind of converged it to a bail hearing and a preliminary hearing on February 19th, especially with the new charge coming up. I really like to vacate that preliminary hearing to set for February 19th. I don't know if we can do that today. Obviously, there has been some negotiations going on in this case, and they've been, I think, healthy negotiations. There is a new charge, so I don't know if we could do that right now. Is vacate that preliminary hearing date on the 19th and set it for a bail hearing next week or not. I got a murder case in Pahrump. I'm down there on Tuesday and Wednesday, but I'll be back in town Thursday and Friday of next week if that's works for anybody.
Yeah, let's do it next Friday at 1:30.
Okay.
Most people are pretty available because we're the only court open on Fridays at 1:30. It's a little hard to have conflict.
You know, there's some lawyers that don't work Fridays, and now here I am working on Saturdays, so I'm doing something wrong, I guess. So, but bail hearing at 1:30, is that right?
That's correct.
And that's January 30th, 1:30, and RJC. I'm putting that in my calendar. Excellent. And
I'll
then
give you a little
Sorry.
preview of the issues that'll be addressed next Friday at 1:30. So you're right that this is the legislature said it's a category B. I think when I started, well, I don't think, I know it was gross misdemeanor, this offense. In my research, and this is my 28th year practicing criminal law, I have not found any effective pretrial measures to stop an individual such as your client from engaging in this behavior. There is no evidence, certainly no conclusive peer-reviewed evidence that GPS, house arrest, residential confinement reduces the risk. The NPRA, you're right, as is in many of these types of cases, is very low. I do not believe that is because the defendant is at low risk. I believe that is because this is a very secretive crime that avoids detection. And I'll give you that the county has taken away the highest level of supervision we had available, which was the Department of Alternative Sentencing, that could actually go into homes and make sure individuals were not accessing certain websites through computers or phones. But the county has done away with the Department of Alternative Sentencing, and we were the only agency that opposed that other than the DAS officers. Nobody else seemed to care. And we believe it has a significant impact on public safety. We believe it will result in some individuals staying in custody because in the least restrictive means analysis, we won't have the ability to supervise them. But even in these types of cases, I had the Federal Marshal's Service on this type of case. An individual that was in California's federal courts was released but resided here. The marshals went in and installed